The moment an officer tells you to stop recording, the law is no longer the only thing in play. Power is, psychology is, perception is. And if you don't understand that, you're already behind. Most people think recording the police is either obviously legal or obviously illegal, and that clarity will protect them. It won't. What protects you in that moment isn't outrage. It isn't bravado. It isn't quoting the Constitution like you're in a courtroom drama. What protects you is a single, calm sentence delivered at the right volume, with the right posture, at the right time. That sentence is this: I am not interfering, and I am exercising my First Amendment right to record. Say it exactly like that. No sarcasm, no edge, no trembling, no added commentary. I am not interfering, and I am exercising my First Amendment right to record. You rehearse that until it becomes automatic, because when the red and blue lights are flashing behind you, or when you're standing on a sidewalk watching an arrest unfold, your brain will not perform like it does right now. Your heart rate will spike. Your fine motor skills will deteriorate. Your memory will narrow. That is biology, not weakness, and in that moment, you need a phrase that carries legal weight without escalating the situation. Now here's where this gets complicated. The First Amendment protects the right to gather information about public officials performing their duties in public. Federal courts across the country have recognized this. The idea is simple. Transparency keeps power accountable. If officers are exercising state authority in a public space, the public has the right to observe and document. But the protection is not absolute. And that's the part most people misunderstand. The right exists, but it exists alongside another concept officers are trained to rely on: interference. If an officer can articulate that your recording materially interfered with their duties, meaning you got too close, distracted them, obstructed movement, ignored lawful distance commands, your right can be limited in that moment. The law allows reasonable time, place, and manner restrictions. This is the trap. When an officer says, "Stop recording," they often aren't actually invoking a clear legal rule. They're invoking ambiguity. They're testing compliance. They're using tone and authority to see whether you'll retreat without question. And most people do, because confrontation with authority is uncomfortable. It triggers something deep and primitive in us. Let me paint you a scenario I've seen play out in body camera footage more times than I can count. A driver is pulled over. It's nighttime. The interior of the car is lit by flashing lights. The driver places their phone on the dashboard and hits record. The officer approaches, sees the phone, and immediately says, "Turn that off." The driver hesitates. There's a long pause. You can feel the tension through the screen. The officer repeats it, louder this time. "I said turn that off." In that moment, the driver's brain is doing 1,000 calculations. Will I get arrested? Will this make it worse? Is he allowed to say that? Should I argue? What almost never happens is the calm response: "Officer, I am not interfering, and I am exercising my First Amendment right to record." Instead, people say things like, "I know my rights," or "You can't tell me what to do," or they start quoting case law they half remember from a social media clip. And now the interaction shifts. The officer feels challenged, maybe embarrassed. The temperature rises. Now this is the part most people misunderstand. Officers are human. They are trained to control scenes. They are trained to detect threats. A raised voice, a sudden movement, a defiant tone. Those things register in their nervous system as potential danger. When you escalate verbally, even if you are legally correct, you increase the odds that they will respond with heightened control tactics. So when I tell clients to use that phrase, "I am not interfering, and I am exercising my First Amendment right to record," I'm not just giving them legal language. I'm giving them a psychological anchor. It does 3 things at once. First, it signals you understand the boundary. Not interfering. That word matters. It acknowledges their authority to control the scene. It tells them you are aware of limits. Second, it invokes a specific constitutional protection without sounding theatrical. You are not shouting free speech. You are calmly identifying a right recognized by federal courts. Third, it creates a record. If the encounter ends up in court, that statement on video becomes powerful evidence. It shows you were calm. It shows you asserted a right clearly. It shows you were not obstructing. Here's where it turns. Suppose the officer responds, If you don't turn that off, you're going to jail. This happens. I've seen it. I've litigated it. Your instinct will be to argue, to demand badge numbers, to accuse. That is rarely helpful in the moment. Instead, you repeat calmly, I am not interfering and I am exercising my First Amendment right to record. If they give you a lawful order to move back 10 feet, you move back 10 feet, and you keep recording. Because the right to record does not include the right to choose your distance. Courts have upheld buffer zones when they are reasonable for safety. If you refuse to comply with a lawful distance command, the issue shifts from recording to obstruction, and now your case becomes messy. Let me be honest with you. There are times when asserting this right will inconvenience you. It may prolong the stop. It may irritate the officer. It may lead to them scrutinizing your vehicle more closely. It may mean you sit on the roadside longer than you would have otherwise. That is the hard truth. Rights are not magic shields. They are legal defenses after the fact. I've had clients who were arrested for recording, charges later dismissed. Vindication came months later, after court dates, attorney fees, stress, missed work. So when I tell you to assert this right, I am not promising comfort. I am explaining leverage. Now consider another scenario. You're standing on a sidewalk. Officers are arresting someone across the street. You lift your phone and begin recording. An officer walks over and says, "You can't record this. This is a crime scene." Is it? Maybe. Maybe not. The mere presence of police does not transform a public sidewalk into a secret zone, but if there's a perimeter established with tape and you cross it, that's different. If you're within the established boundary, you may be trespassing or interfering. So again, your phrase, I am not interfering, and I am exercising my First Amendment right to record. If they say, back up, you ask calmly, how far would you like me to stand? That question is powerful. It shows cooperation. It forces specificity. Ambiguity shrinks. This is where ambiguity is often weaponized. Vague commands like move back without distance create room later for officers to claim you were too close. Clarifying reduces that space. Now let's talk about adrenaline, because this matters more than people realize. When you perceive authority confrontation, your amygdala fires. Stress hormones flood your bloodstream. Your hearing narrows. Your vision tunnels. You may not even remember your own words later. This is why rehearsing the phrase matters. You want it stored in procedural memory, like a reflex. The goal is to bypass panic. I tell people to practice saying it in a mirror, slowly, calmly, neutral face, shoulders relaxed, phone steady, but not shoved into anyone's face, because body language is part of the legal equation. If your stance looks aggressive, even unintentionally, it can be described that way in a report. And reports matter. Officers write narratives that frame events. If your posture reads as confrontational, that word may appear on paper. Juries read those words. Here's where this gets even more nuanced. There are exceptions. Sensitive locations like inside police stations, certain secure areas, or situations involving undercover officers can complicate matters. Recording in public is generally protected, but privacy laws may restrict audio recording in some states if conversations are not public. Most traffic stops and street encounters are not private conversations, but laws vary. You must know your state's wiretapping rules. And then there's the issue of qualified immunity. Even if your right was clearly established, an officer might not face personal liability unless the violation was obvious under existing precedent. So again, we are talking about rights in principle versus outcomes in reality. I once handled a case where a man recorded officers during a DUI stop, his friend's stop, not his own. He stood about 15 feet away. He said nothing. One officer told him to leave. He calmly replied, I am not interfering and I am exercising my First Amendment right to record. The officer arrested him anyway for obstruction. The charge was dismissed. The body camera showed he never crossed the line. But it took 6 months, it took litigation, it took pressure. So when you hear me emphasize that phrase, understand what it represents. It is not defiance, it is documentation. It is the creation of a clean record for a future judge. This is the part most people misunderstand. You are not arguing for the officer's benefit. You are speaking for the camera, for the prosecutor, for the court reporter who may later transcribe your words. Now imagine the officer ignores your statement and physically tries to block your camera. Do not push past them. Do not turn it into a physical contest. Keep the device steady. Keep your voice even. Repeat the phrase once more. If they seize your phone without a warrant, do not resist physically. Say clearly, I do not consent to the seizure of my property. That is a separate phrase, but it serves the same purpose, preserving the issue for court. Notice the pattern: calm, specific, non-combative, repetitive. Officers sometimes rely on what I call compliance momentum. If they can get you to obey a questionable command early, it sets a tone. You fall into a pattern of submission. Breaking that pattern politely but firmly can change the trajectory of the encounter. But there's another hard truth. Some officers will escalate anyway. Some will interpret any assertion of rights as a challenge. You cannot control that. What you can control is your own clarity and composure. This is where it turns into a mindset issue. If your goal is to win the argument on the street, you may lose the larger battle. If your goal is to preserve your rights for later review, your strategy changes. You speak less. You move slowly. You comply with lawful safety commands while maintaining your position. I am not interfering, and I am exercising my First Amendment right to record. Say it without anger, without a smirk, without a lecture. And if the encounter ends without arrest, you leave. You do not linger to debate constitutional theory. You do not chase the officer down with follow-up questions. The recording speaks for itself, because at the end of the day, this is about controlling what you can control in a moment designed to make you feel small. Power dynamics are real. Badges carry authority, but the Constitution is not a rumor. It is enforceable. The right to record public officials in public spaces performing public duties has been affirmed again and again. The friction arises in the gray areas: distance, tone, timing, safety. So rehearse the phrase, not angrily, not theatrically. Rehearse it until it feels boring, because in the moment, boring is powerful. I am not interfering, and I am exercising my First Amendment right to record. That sentence keeps you anchored. It keeps the interaction framed in law rather than ego. It signals knowledge without aggression. It preserves evidence. It acknowledges limits. And if you ever find yourself with flashing lights in your mirror or tension on a public sidewalk, your heart pounding and your mouth dry, you won't have to invent courage on the spot. You'll already know what to say. Say it calmly, say it clearly, and practice it until it's automatic.